Hi there, I am Tristan. Today, we would like to present to you a very interesting story which concerns a famous legal case. I suppose that each student or lawyer might have heard of this case for at least a few times because it is a landmark case under the law of tort, which is under the negligence field. And yes, it is the case of Donoghue and Stevenson. Now, let's have a case brief on the case facts on the case. Let's go!
On the evening of Sunday, 26th of August 1928, during the Glasgow Trades holiday, Miss Donoghue took a train to Pelsey. In Pelsey, she went to the Meadow Cafe. Miss Donoghue and a friend chose a place to sit in the cafe. The waiter handed them the menu to have a look. They were looking through the menu in the high-tone cafe. A friend who was with her ordered a pear and ice for herself and a Scotsman ice cream float, which is a mix of ice cream and ginger beer, for Miss Donoghue. After a short while, the waiter came and served the food and drinks which they have ordered. The ice cream float was served in the wine glass first before pouring the ginger beer into it. The owner of the cafe, Francis Minghella, brought over a tumbler of ice cream and poured the ginger beer on it from a brown and opaque bottle. Although the bottle was labeled as Stevenson, it is possible it did not originally belong to him. Bottles were often reused and in the process occasionally returned to the incorrect manufacturer. Moreover, Stevenson initially claimed that he did not issue the bottles matching the description which is provided by Miss Donoghue. Miss Donoghue drank some of the ice cream float. The ginger beer had been manufactured by David Stevenson, who ran a company producing both ginger beer and lemonade at 11 and 12 Glenland Paisley, which is less than a mile away from the Meadow Cafe. The owner of the cafe poured the remaining ginger beer into the tumbler. A decomposed nail also flowed out of the bottle. The ginger beer bottle was made of opaque glass. It wasn't transparent and they couldn't see what was inside. After Miss Donoghue drank a couple of sips, she started to feel a bit uncomfortable. However, she thought that it would be a small matter. Later then, she realized that her stomach starts to hurt. Now, she started to be a bit worried. However, Her stomach pain is increasing, and Miss Donoghue finally realized that something is wrong. As she looked into the wine glass, both her friend and her were stunned and shocked. To their shock and horror, the two women saw something that was to shape a lot like a partly decomposed remains of a snail. Both women gasped in disbelief. A rotten animal inside a bottle? That is completely unacceptable.
In the hospital, Mrs. Donoghue stated that she was made ill by what she had seen. It's undoubtedly a fact that she indeed received medical treatment from a doctor for 3 days after the unfortunate event. The treatment was for gastroenteritis. This is a very serious illness of the bowels. Your stomach hurts and becomes swollen. It can last for weeks or months and is very painful. She suffered a lot. She also received medical treatment in a hospital in Glasgow for 3 weeks. She made an additional claim that she had suffered from a nervous shock. Mrs. Donoghue felt that she had been subjected to a lot of pain and suffering. She thought she deserved justice. Mrs. Donoghue decided to bring an action against the manufacturer of the ginger beer, Mr. Stevenson. He is therefore the defendant in this case. Well, this is when it gets really interesting. She hired a very brave and determined solicitor, Mr. Leachman. Despite the fact that there was no precedent for such an action, Mr. Leachman, however, decided to take the case. Mrs. Donoghue decided to claim damages to compensate her for all her troubles. Damages are, of course, the most common remedy. But she had a huge problem. It was her friend who had ordered and paid for the food and drinks. Therefore, there was a contractual relationship between her friend and Mr. Minchella, the pub owner. Mr. Minchella was undeniably, without a shadow of doubt, in breach of the contract of sale.
Plaintiff, you may proceed.
My lord, Miss Donoghue, my client, was served with a bottle of ginger beer which contains part of the decomposed snail. Due to this fact, my client is now suffering from severe personal shock, but unfortunately, if the strict principle in the law of contract is followed, she is unable to sue the manufacturer of the ginger beer.
You may proceed.
After Miss Donoghue was being examined, I hereby declare that she is diagnosed with gastroenteritis and now being in a state of severe shock. This is a very serious illness of the bowels. The stomach will hurt and become swollen. It can last for weeks or months.
You may proceed.
This is absurd and totally not acceptable. I have been suffering from physical and mental disorder for the past few days and I need a reasonable remedy. This is not fair and I need a justice.
Defendant, you may proceed.
My lord, Miss Donoghue shouldn't be liable to sue my client because she is not the one who bought the ginger beer in the first place. Therefore, there is no contractual relationship between my client and Miss Donoghue. And as we apply the strict application of contract law, it is stated that one party could not sue another party if she or he is not involved in the contract.
This case forms the basis of law of tort. Therefore, I will choose to create the neighbor principle to mitigate the severity of the hard and fast rule of treaty of contract and to allow a just and fair decision to be reached. The neighbor principle provides that if the manufacturer could foresee that a consumer would have suffered harm if he or she is negligent, then the person can be sued in the law of tort. The person need not to be a person under a contract, but it can be anyone in proximate contemplation of the manufacturer. This is called the neighbor principle. The rule that you are to love your neighbor becomes in law. You must not injure your neighbor. You must take the reasonable care to avoid acts or omission which you can reasonably foresee would be likely to injure your neighbor. Who is my neighbor? The answer seems to be the person who are so closely and directly affected by my act that I ought to have that in mind when I am considering this act or omission.
Hi everyone, my name is Yong Hao and I'm now going to talk about one of the elements that was established in the case of Donoghue and Stevenson, and it was the negligence. The House of Lords ruling affirmed that negligence is a tort. A plaintiff can take civil actions against the defendant if defendant's negligence has amounted to the plaintiff's injury or the loss of property. But previously, the plaintiff will have to demonstrate a contractual arrangement for a negligence to be proven, such as a sale of an item or simply an agreement to provide a service. And in this case, Mrs. Donoghue did not purchase the ginger beer. Therefore, she could not prove the contractual arrangement with the manufacturer of the ginger beer. However, Lord Akin established that the manufacturer of the ginger beer, who was Stevenson, he will have to be responsible for the integrity of his product. All in all, it's important for us to identify and also appreciate the principle that we can establish from the case of Donoghue and Stevenson.
Hi everyone, it's Cindy here. Today, I'm going to bring up the second issues that was being established in the case of Donoghue and Stevenson. According to Lord Atkin Ratio Decidendi, he stated that the manufacturers of a product has an obligation to take a reasonable care of its consumers, and this is called the duty of care. It is typically established between the relationship of the manufacturers and the end users of the products. So, the precedent has evolved and now become a basic laws that protects the consumers from those contaminated or faulty goods. And those practices began as common law, but now many have since been codified into legislations such as the Trade Practices Act.
Based on the English law, neighbor principle is defined as which a person has a reasonable care towards an act that will cause foreseeable damages towards a neighbor. Neighbor is therefore defined as which parties or a person that would be directly or closely affected by such actions. This standard of care was established by Lord Atkins in the case of Donoghue and Stevenson. In this case, the court held that they will be overcoming the problem of privity of contract and therefore come up with an alternative problem to avoid the issue. Therefore, the court held that there is a negligence between the owner and Ms. Donoghue. All in all, the neighbor principle provides a flexible approach towards cases, but it would not cause a floodgate effect. This is because no duty of care would be obliged by those who are not close enough to be defined as neighbors.
Hi, I'm Zunying. Although the neighbor principle has become the guideline on the extent of the duty of care, the court might encounter some situation that might need to further elaborate its basis theory. For example, in the case of Halliburton versus Heller, the bank has made a negligence statement. The House of Lords held that plaintiff could establish a duty of care if it could be shown that the special relationship exists between the parties. So, what is special relationship? The special relationship could be found that the party seeking information was trusting the other parties would exercise a degree of care that it would be reasonable for him to do so. The case of Hadley Burn was built a further law on the neighbor principle, and the law of duty of care was further applied in the case of Caparo Industry versus Dickman. In the Caparo test, the Lord Devlin has explained that the special relationship as being one which is equivalent to the contractual relationship. The Lord King stated that, in addition to the foreseeability of damage, the necessary condition in any situation that needed to establish the duty of care would prove that there is an existence of relationship between the parties who owing a duty and the party to whom it is owed to. This is defined by the law as one of the proximity. The situation should be the one in which the courts consider is fair, just, and reasonable to impose the duty of care on the parties for the benefits of others.
Hi, my name is Clifford. Today I will be seeing the Caparo's test. So in the case of Caparo, indictment, Caparo Industry purchased shares in Fidelity in reliance of the accounts which stated that the company had made a pre-tax growth of £1.3 million. In fact, Fidelity had made a loss of over £400,000. Caparo brought an action against the auditor, claiming that they were negligent in certifying the accounts, but the court held that no duty of care was owed, as there was no sufficient proximity between Caparo and the auditors, since the auditors were not aware of the existence of Caparo, nor the purpose for which the accounts were being used by them. So in the Caparo test, it is made out of 3 stages. First, foreseeability, second, proximity, and fairness. The first stage revolves around whether it is foreseeable that the defendant's carelessness could cause damage to the claimant. It is not and cannot be an issue between these parties that reasonable foreseeability of harm is a necessary ingredient of a relationship in which a duty of care will arise, which is stated in the case of Yuan Kun Yu and Attorney General of Hong Kong. A prime example of foreseeability can be seen in the US-based case of Pulse Gulf and Long Island Railroad Co. In the case, although it was possible to trace the claimant's injury to the defendant's negligence, in applying a test of foreseeability, the courts found that it was not foreseeable that the claimant would be injured. It is also common ground that reasonable foreseeability, although necessary, is not a sufficient condition of the existence of a duty. This was observed in the case of Hughes and Chief Constable of West York and has been said almost too frequently to require repetition. The second stage is based on whether there is a relationship of proximity between the defendant and the claimant. This does not dictate that there must be physical proximity, rather than there must be a connection between the two. An example of proximity can be seen in an Alcock's case, where the members of the general public coming across the aftermath of the Hillsborough disaster and suffering nervous shock as a result were held to not be owed a duty of care, because the link between the defendants and claimants was held to be too distant. The third and final stage of Caparo involved establishing whether it would be fair, just and reasonable for the courts to find that the defendant owed a duty of care to the claimant, which is stated in the case of governors of the Peabody Donation Fund and Sir Lindsay Parkinson and Co. Limited. Owing to the vague nature of this criteria, this stage can be thought of as somewhat of a safety valve, allowing judicial discretion in cases where public policy might dictate that it would be unreasonable for a duty of care to be held to exist, which is stated in the case of Mark Rich and Co. and Bishop Rock Marine Co. Limited. It was consideration of this kind which Lord Fraser of Teddy Burton had in mind when he said that some limit or control mechanism has to be imposed upon the liability of a wrongdoer towards those who have suffered economic damage in consequence of his negligence, which is stated in the case of Candlewood Navigation Corporation Limited and Mitsui OSK Lines Limited. So if all 3 of these stages are passed, the case can be said to have satisfied the Caparo test, and thus a duty of care can be said to exist.
Alright guys, that's all for the video today.
I hope you enjoyed the video.
Feel free to comment below.
Thank you.